Good afternoon, everybody. The previous videos, we took a look at civil liberties and how important they are in protecting us from government infringements. But I wanted to take a moment again to look at the differences between civil liberties and civil rights, especially because we tend to use the word liberty and right interchangeably. The first thing that I want you to note is that when I say civil liberties, recognize that I'm talking about things like limiting government's power here. That's indicated right here on the slide as well. It's telling the government what they can't do. Okay, and the civil liberties, anytime you're talking about protections from government infringements or stepping on whatever rights that you have, you're talking about the due process clause. Whereas when you're talking about civil rights, in order to protect civil rights, it's going to require a government action, typically there. And oftentimes, at least in the last few decades, it has been the federal government protecting at the state and local level. It's intended to protect against discriminatory treatment. So whereas the civil liberties utilize the due process clause of the 14th Amendment, these civil rights or our civil rights stem from the equal protection clause. And that's what I wanted to speak with you guys about next. The Equal Protection Clause was a big part of the Reconstruction period, and I'm not going to get super heavy into the history behind it, but you do need to note that it's been utilized in cases like Brown v. Board of Education, which we'll be talking about shortly, to Yick v. Woe, or Yick Woe versus Hopkins, excuse me. And what it indicates here is that non-citizens also have this equal protection rights. Many times we get a little confused in thinking about, well, who ultimately has those rights? If you're anywhere within the United States or its jurisdiction, you do have certain equal protection rights. And it's important to know where that comes from. Also, it's important to note that because the 14th Amendment relates to state and local level, it allows that extension of those. But before equal protection issues really come to play, it's important to note that the U.S. Supreme Court utilizes three different tests to be precise. They use a strict scrutiny test, an intermediate scrutiny test, and a reasonable basis test. Now, you guys looked at things like Shaw v. Reno that involved voting rights, and we'll be taking a look at that in a later video as well. But because that involved race, recognize that if the government is going to treat groups differently, it has to pass the highest bar possible in order to justify different treatment of different groups. Okay, so view strict scrutiny as the highest bar possible that a state has to reach in order to say, hey, we have to treat these groups differently. Intermediate scrutiny, though, is treated a little bit differently. For instance, the Virginia Military Institute just had a basis of only accepting men. Well, that rule was challenged in 1996 when a woman ultimately argued that she had every right under the Equal Protection Clause to join the university. Well, at that time, the U.S. Supreme Court created a new test, and that was the intermediate scrutiny test, but recognized that as a lower bar than strict scrutiny. In other words, the court is tolerating a bit more gender discrimination than they are racial discrimination. Not sure why. That would be something worth looking into. But it is worth noting that the Virginia Military Institute, since 1996, did begin permitting women, and obviously that's paved the way for things like Scouts of America converting from Boy Scouts. Admitting more people. Title IX is related to this as well, and we'll get to that a bit later also. But reasonable basis is the lowest bar to pass. This is basically states and local governments can create any number of different reasons for why they're treating groups differently. And this is something typically involving age or income, something a little less than gender or race in this. It's worth kind of exploring about why that might be the case, but it requires a lot more time analyzing those points. But for now, I just want you to note that strict scrutiny is going to require the highest level of state rationale for why they're discriminating against different groups. The reason for that, guys, and the reason why they're looking at that in the past is that it's undisputed that there's been a legacy of racism within our country. The question is how far that legacy of racism goes. For instance, sometimes you'll hear terms thrown out like institutionalized racism. And that's the notion that it isn't just individuals that are racist, but that public schools are racist, or that local law enforcement agencies are racist, or state legislatures or national legislatures are racist. You can look here at the polls here to determine how different races view the pervasiveness of institutionalized racism, but it's worth noting because that really gets at the heart of how the court and how different individuals are feeling about charges of discrimination or charges of my equal rights have been denied to me. So let's look back a little further here at Dred Scott versus Sanford. In this particular case, the U.S. Supreme Court, in all its infinite wisdom, determined that blacks were not only not citizens, but that because of how they were viewed at the time of the creation of the U.S. Constitution, okay, they were inferior people to the rest of the population. That really fed the notion that they were property for many, justifying fully the use of African Americans as slaves at the time. The 14th Amendment completely upended or overturned this particular ruling. And that's what's important to note, how Congress and the states can challenge the court's rulings on this. And this is a perfect example of that. But Dred Scott versus Sanford, the 13th Amendment freeing slaves, the 14th Amendment granting them equal protection, and even later the voting rights did not end things like the Jim Crow laws and other forms of discrimination. Prior to the Jim Crow laws, you had black codes. With the Jim Crow laws, the idea was that you would have separate systems for different racial groups. And this is based upon a case that we'll be talking about in just a moment, Plessy versus Ferguson. But the idea is, just as you see in these signs, public schools would be for different minority groups, water fountains, theaters, restaurants, any number of different things. If a restaurant served different groups of people, they might have to go through separate entrances there. But again, this begs the question of, okay, so we know that there's an equal protection clause, so how is this justified? Again, we'll look at that with Plessy versus Ferguson. You read The New Jim Crow, and what I want you guys ultimately looking at is the merits of her argument relative to what it is that we're looking at today. Obviously, Michelle Alexander is making the argument of institutionalized racism within our justice system. Why don't you take a look at the statistics and see ultimately what sort of laws are currently in place and kind of relate it to some of what you may have remembered from reading the book this past summer to determine whether or not she has a point. Is there a case for the new Jim Crow? In other words, are the equal protection rights of African American citizens especially being infringed with our justice system? But to address some of why discrimination in the Jim Crow laws were allowed to stand for as long as they were are three words, what it comes down to: separate but equal. The idea is that, look, you can have separate schools, you can have separate theaters, you can have separate community pools as long as they're equal. Now, obviously, that begs the question, how are you measuring equality? And that certainly was used a number of times in the courts. But that decision stood for another 58 years until Brown v. Board. And that's ultimately what I want to talk with you guys about now. What was interesting about this, guys, and this is what's really worth noting here, the court typically follows something called stare decisis, and that is let the decision stand. And the reason why they do that is that you can't have laws and rulings changing every couple of years because it creates no consistency of laws. It creates chaos. Nobody knows what the rules are. So when the court unanimously determined to change the laws of whole regions of the United States, this was a huge deal, and it was considered by many an act of judicial activism. In other words, the court isn't interpreting the law, they're making the law. And I'll let you determine whether or not you agree with that. But what is interesting is that the court utilized data from psychologists to make their decision. And that was something unheard of in the courts up to that point. I think we can all look back and ultimately say what a wonderful decision it's been, but it was seriously challenged for decades because of that belief of judicial activism, that they were legislating from the bench, which is why you had to have further actions from the executive branch. You've heard about Eisenhower sending the troops down to Little Rock, but that's not something he did, um, like quickly there. That's not something he really wanted to do. And even then, you saw a lot of resistance to that. You may have watched Remember the Titans. That was in the 1970s where some of that resistance was occurring. And it went far beyond the 70s as well. So did it eventually end in the 1970s? Did communities change? Well, sort of. But the big thing that I want you to hold on to, and the reason why it's so important to look at the civil rights movement in light of education, is the belief that education is the great equalizer, that education creates the greatest opportunity for equality within the United States there. So we wanted to make sure that that equality was provided. But here's the challenge. People go to school where they live. And if where they live is in a rundown community with a limited tax base, okay, and that's the only place they can live because of things like redlining, where banks and local realtor associations, with the support of local governments and even the state and federal governments, who many times created the guidelines earlier than they set them up, this prevented people from living where they may have otherwise been able to live. In other words, are people being treated equally? Is the Equal Protection Clause being followed? So while it may have been followed in education, is it in housing? And if it's not in housing, what should we do about that? How do we change those communities there? And guys, that relates to something called de jure segregation and de facto segregation. And just as you see here, de jure segregation is segregation by law. So after Brown v. Board of Education, schools could not segregate based on race. But de facto is something that's a bit more subtle, a bit more insidious. And de facto isn't necessarily segregation by law, but it's segregation by practice. In other words, if a state or local government or the federal government is engaging in segregationist policies or practices, that's de jure. But if it's private individuals or private institutions that are engaging it, then it's simply de facto. You can imagine which one might be a little more controversial in addressing. And that creates the real problem. Shirley Chisholm was an African-American activist and the first African-American woman to run for the presidency. You can see how she explains the difference between de jure and de facto segregation. And you can look at some of the things here to differentiate between those two. But the simple fact is that this made pushing civil rights further than what it was quite a bit more difficult. And if we're talking about equal protection of the laws, what exactly does that mean? What exactly does that grant different groups if they're prevented opportunity in some of the areas like housing there? Now, granted, the Civil Rights Act of 1964 addressed much of that, and it even addressed things at a private level, utilizing not a constitutional amendment, but the Commerce Act. It banned discrimination at all levels of society there, be it a private insurance company or a hotel. They utilized those specific actions. Hartz versus Atlanta helped solidify that case, where the U.S. Supreme Court now ultimately said that you cannot discriminate against biracial couples or African Americans coming into your hotel because you serve people across state lines. That's interstate commerce. Therefore, the Civil Rights Act stands there. And that creates the basis for that. The Voting Rights Act goes a little bit further than that, and it ultimately serves as the culmination of the civil rights movement of the 1960s. Where they go from there, we'll take a look at in some of these later videos, but I want you to be thinking about how successful have these amendments been? To what extent has discriminatory behavior or actions or institutionalized racism, to what extent does all that still exist? Thanks for the time, everybody, and I hope you found this informative.